So in the realm of statutory interpretation, it doesn't seem at all odd to think of decision makers as proceeding in two stages when they ascribe meaning to statutory language at the rule level. In the first stage, they try to identify the provision's original meaning and the range of its indeterminacy. That will entail reading the provision against the backdrop of various linguistic and legal conventions from the time of enactment, some of which may resolve what initially seemed to be ambiguities on the face of the provision. But to the extent that the original meaning of the provision is intractably ambiguous in some respect, decision makers will proceed to the second stage, choosing from among the menu of options that they have identified at the first stage. In making that choice, they might well draw upon non-originalist considerations, facts or arguments that would not have been available to people at the time of enactment. I think that principled originalists can have the same view of the process of ascribing meaning to the Constitution. The first stage, where people do their best to figure out the meaning that was fixed as of the founding, is what we're calling interpretation proper. But to the extent that original meaning is indeterminate in some respect, people who proceed to advocate a particular choice within the menu of interpretive options are engaging in a species of what we're calling construction. What's more, to the extent that the original meaning of the Constitution has indeed run out, the kinds of arguments that are made during the construction stage don't have to be originalist. As with statutory construction, one can imagine different views about which institutions of government should be involved in construction of the Constitution. If one has a Thayerian conception of judicial review, one might argue that courts should hold acts of the other branches unconstitutional only if the Constitution clearly forbids those acts, that is, only if the courts can identify the unconstitutionality of those acts through interpretation proper without having to resort to construction. But that's a principle about judicial review, not about how to ascribe meaning to the Constitution per se. Even if we had a Thayerian conception of judicial review, legislators and other decision makers would still need to ascribe meaning to the Constitution on contestable points, and that would still require some construction. So again, we would need to face the question of whether principled originalists can take account of any non-originalist considerations during the process of construction, and again, I would say that the answer is yes. From the standpoint of originalists, the primary danger of this theoretical argument is that decision makers will use it to detect indeterminacy where indeterminacy doesn't really exist. That danger might loom particularly large when the decision makers in question are courts that have rejected Thayerianism and that will enforce their own constructions of the Constitution at the expense of the acts of the other branches. If we invite courts to use different practices with respect to interpretation than they use with respect to construction, they will surely make some mistakes about the location of the line between interpretation and construction, and maybe mistakes are particularly likely if the consequences of classifying some question as a matter of construction rather than interpretation is that judges can legitimately take account of present-day considerations. Maybe we should be worried that judges will fudge the line between interpretation and construction so as to have more flexibility to ascribe their own preferred views of policy to the Constitution. If one thinks that the line between interpretation and construction will be too hard for courts to draw and will invite too many deviations from aspects of the original meaning that are actually determinate, one might be inclined to favor a blanket rule that will avoid the need for courts to draw that distinction. Purely as a practical matter, somebody with that concern might advocate the following blanket rule. Present-day courts should ascribe meaning to the Constitution at the rule level only on the basis of considerations that would have been available to members of the founding generation, and should try to settle on the same bottom line that members of the founding generation might have settled upon, without regard to whether that bottom line is a matter of interpretation or construction. My time has probably expired, but let me sketch out two quick reasons to be skeptical of that blanket rule. First, to the extent that we're concerned about deliberate misbehavior by courts, I doubt that any interpretive theory can solve that problem. Certainly, any plausible version of originalism is going to require courts to draw subtle distinctions. such as the distinction between the original meaning of a provision and the original expected applications of that provision. If courts are determined to misbehave in the interpretation and application of the Constitution, they will have ways to do so, even if we tell them to ignore the distinction between interpretation and construction. Second, the blanket rule that I described runs up against the limits of our historical knowledge. To apply it, present-day courts will have to speculate about the content of the constructions that founding-era courts would have adopted on questions that the original meaning does not control. That project is itself going to be prone to error. If the only reason for courts to engage in it is just to avoid having to make other decisions that might also be prone to error, I'm not sure what we've really gained. So I am on board both for the theoretical distinction between interpretation and construction and for the practical judgment that courts should be allowed to try to draw that line. I am not inclined to tell present-day courts to pretend that the original meaning of the Constitution is always completely determinate, even at the rule level. As a result, my response to the topic for the panel, does originalism always provide the answer, is that it depends on the question. Originalism does provide answers to questions about the range of meanings that can permissibly be ascribed to the Constitution, but it does not always tell decision makers which meaning to pick from within that range. Thank you.